like to draw your attention to your name tags. There is a QR code on the badges, and if you scan it, it will take you to a conference booklet, which will give you a detailed itinerary of all the events that we'll be having. So I request you to visit the site. The first session is hosted by Poovayya Co. The topic for the session is data privacy and cross-border arbitration, navigating DPDPA, GDPR, and global frameworks. The session will be moderated by Ankit Parhar. The speakers include Harini Sudersan, Justice Kurian Joseph, Dr. Sapna, and Mr. Saurabh Awasthi. I request the speakers to kindly come on stage. Thank you. I'm sorry, I forgot. We'll be also having Malavika Prasad on the panel.
All right. Good morning, everyone. I hope the audio is clear at the back, everybody. Monday morning, thank you for battling Bangalore traffic. Thank you for being here. Hope you had a nice coffee and we're ready for an intriguing discussion here. The topic is data privacy in cross-border arbitration, and particularly navigating the DPDP, the GDPR, and global frameworks. We have a varied and esteemed panel here for you. Like the host mentioned, we have Justice Kurian Joseph. He's a former judge of the Supreme Court of India. Justice Joseph has had a distinguished career. He served in the Apex Court from 2013 to 2018. I don't know, sir, if this is true, but I got this fact that you've authored more than 1,000 judgments, and I believe that record still stands. So that's something. I don't see that record being broken also very soon. And Justice Joseph had authored landmark judgments on privacy, constitutional law, and arbitration. And we look forward to his insights today. We have Harini Sudersan. She's a partner at Poovayya Co, dealing with data protection and privacy. We have Dr. Sapna S. She's a professor and head of department at the School of Law, Rice University. Dr. Malavika Prasad. She's a partner at Sadananda and Prasad. And we have Saurabh Awasthi. He's a general counsel at Kyndryl, India. Before we start off with the topic, I would just request Justice Joseph to give a few thoughts on what are the challenges typically faced in international arbitrations. Yes? So generally your thoughts.
Ankit, and a very warm good morning to all of you. I'm glad that you have spared some time to think about this ADR and international commercial arbitration and data privacy and its need for protection standards as well. We hardly get any time to think. We always get time to think, speak and argue. But here we are together to see whether something we could do, we could propose, we could do ourselves to take things forward in the right direction. And you asked me about the challenges in the international commercial arbitration. If you speak from the Indian perspective, we had a very bad name. Instead of ADR, we were seen as ADG. ADG is additional dispute generation centers. Alternate dispute resolution became. Reason is our compliance laws. Reason is our implementation protocol. Reason is our inadequate structural support systems for international commercial arbitration. I will not, and I cannot, since we have a confidentiality not only in the Arbitration Act in Section 42A, but here also, as arbitrators, we always maintain this confidentiality. In an international commercial arbitration, in fact, we had to get a team to come and inspect whether there is a center available in India. They tried India, in Delhi, then Mumbai, Hyderabad. We couldn't, because the type of infrastructural support they expected, then they need also, is not there. We had first phase elsewhere in the world. Second phase, we really wanted to be in India because it's a dispute concerning an Indian entity as well, though it is a commercial international arbitration. But unfortunately, despite touring around and inspecting also, we couldn't find a place. So the physical infrastructure we are lacking when compared to the systems we have. And one place we found in India is 6 times costlier than the IDRC London. Just imagine the way things are shaping in India. So we need an institutionalized approach and institutional mechanisms in place. Secondly, the systems and practices, we need to get rid of this bad name that become so friendly after the 2015 amendment, where you have the mandatory deposit, you have the scope has been limited despite SWAP try slightly bringing a mischief, but it has been taken away, except maybe for that curative issue. Otherwise, it is almost stabilized. Compliances have increased. I don't think internationally is any international award that is pending in execution for more than a bit of a time, because all courts, while we sitting in Supreme Court also, we have given strict directions that in executions we need to take special care, because that's a bad name. In civil disputes in India, as you know, it's easy to get a degree, but to get the degree executed, then comes the real litigation. That is the bad name. So we have been trying to simplify, but in the process, it has only generated more complications. So I think, Ankit, we need to get rid of this sort of bad names we have on the systems and practices, particularly on compliances as well. In terms of the interpretations by the Supreme Court and in terms of the policy by the Parliament, we have been moving forward by bringing successive amendments, as many amendments as the Constitution had. Probably we are trying to compete in arbitration also. We have so many amendments after the 1940 Act. We have the 96 Act also. We have got a few amendments in the substantive law, the procedural law, and in the regulations as well. But despite all this, it shows that there's an honest and bona fide attempt on our part to cope up with the standards or requirements of dispute resolution. After all this is meant for resolution of a dispute, not decision of a litigation. The approach is totally different. So I was also thinking, after coming over here also, why not we also think about something like Section 28, which as time permits, there's another question I will address also. Thank you.
Thank you, sir. So I take it that, yes, there is a lot to be done, but the steps are there. I guess we are moving, perhaps not at the pace that we would expect and that we want. So just another couple of points on this before we move on to the next questions. We find that the public sector is moving away from arbitrations, and the government is pushing for arbitrations. Do you see this as a bit of a contradiction? And do you think it's a positive move, or do you think public sector should be leading the way by treating arbitration and maybe mediation as a mode of dispute resolution rather than going back to civil courts?
100%. That's why you have taken me to that Section 28 also. See, the original Indian Arbitration Act is, you see, it is Arbitration Conciliation Act. Now that the Mediation Act has come, it has been replaced. But Indian approach to dispute resolution outside court has always been conciliatory. That is very fundamental to this. Even before we had all these statutory regimes in practice, in our villages, there were the village heads, having their own systems. Even now in some parts of Karnataka also, we go to the Mangalore side, they have their own village heads, calling and settling disputes. They settle disputes more majestically and more honorably than we settle disputes in courts, protecting the self-respect and the dignity of the parties as well. So I would agree with you, Ankit, that we need to sharpen our tools in terms of this mediation, putting mediation more into arbitration and trying to find a solution to the dispute. That is dispute resolution, not a solution answer to a question. That's why I'm in my entire practice as an arbitrator, well, it's 7 years now, international and domestic. I've been dissuading parties from framing issues, because it's not for issue resolution we are here. We are here for dispute resolution. So let us focus more on the dispute that you have and find a solution, or rather a resolution of these disputes. Having said that, third time I'm referring to section 28. 22, in fact, permits or rather contemplates, provides for the parties to provide an equitable jurisdiction on the tribunal. In case, the parties are in a position to trust the tribunal. After all, it's a matter of trust. In arbitration also, there's a very serious element of trust. That is why the only strong ground on which you can challenge an award is deficiency of trust on the arbitrator. So there is a presumed trust in the arbitrator. Then why don't you also give this liberty to the tribunal to try for an equitable solution to the disputes? And on the question of MSMEs,
Yes.
this medium, small scale, all these industries, they were actually being encouraged to dispute to resolve their disputes outside court. That is, in principle, it's there, still there. But recently, the trend I find, I do not know why this trend has come. There are government circulars, actually restricting their scope for arbitration. Don't go for an arbitration where the amount involved is beyond about 10 crores. What does it mean actually that you don't require a tribunal for that? Settle your disputes before 10 crores. You can go to a commercial court of an ordinary civil court junior division, I think, if not senior division. You can settle your disputes. But if you really intend to have a commercial approach on dispute resolution in terms of efficacy, in terms of expediency, and in terms of settlement in a way acceptable to all the parties, probably we need to change our actual approach. This is not the way that we have to approach. This has got a very bad name for India, in the sense that on one side you always bringing on amendments after amendments, making India a hub for arbitration. If you don't make dispute in India, at least you make India by way of a dispute resolution hub. But at the same time, on the other side, public sector being taken away. In fact, if I'm not exaggerating, more than 50% of the institutions on one side in arbitrations are public sectors only. And if they are cabin and confined to a very, very minuscule what they call jurisdiction in terms of their financial independence, there is no point in going for arbitration. So that's a real death blow to our move to make India for a commercial hub.
Yes. Thank you so much, sir. Dr. Sapna, now Justice Joseph has laid out where we stand, and I believe to be an international hub, first we should fix our domestic arbitration system. While that is happening, let's get back to our topic now. If there is a data breach faced by an entity, let's say that we'll just jump straight into that, right? There are various GCs and so on here who will have this insight. You are a data processor, you take data of your customers. If there is a data breach, what happens? And are there any avenues of dispute resolution here? Is there some kind of intersection in arbitration? What are your views on that?
Thank you, Ankit. Thank you for having me on this panel, and a special one to Mr. Dharmendra Chatur, and it's a privilege to be here. Let me first go back to trying to understand the DPDPA itself. Throwback to July 2015, the Permanent Court of Arbitration was having an arbitration. It was a high-profile international maritime arbitration between China and Philippines. China was not participating in the arbitration, but then Philippines was, and the arbitration was going on. On the third day of arbitration, an independent cybersecurity firm found that the website of PCA was under exploit. There was a malware that was planted, and there was a potential danger of data breach, confidentiality, privacy, and all issues which were at huge risk at that point of time. So just imagine the kind of the global data flows, the cross-border data movement, and not to forget the various jurisdictions that it will have to travel. I mean, it just creates so much of complexity in its own way. So to start with the first part of your question about the DPDP itself, this is the why and the what of the DPDPA. Now, apt at this juncture, probably we will just quickly take a look historically why the DPDPA itself. Now, 2017 was the Puttaswamy case, which recognized the right to privacy as fundamental and therefore necessitating the protection legislation. And then the Sri Krishna Commission in 2018, there were three major issues which were brought about here. One was the localization, the fiduciary accountability, and the user rights. And the bill, and of course, then you have the DPDPA Act. Now, to come back to your question about how is the dispute resolution, the DPDPA has provisions which makes it pretty much clear about what should be the provisions which relate to the data protection and if there is a breach. Now, it starts with these provisions which speak about the first one being the first one being Section 33, which speaks about a board. There is a board that is called as the Data Protection Board of India. Now, this is in Section 28, which says that there is a board, and this is going to be a specialized board, which is specifically created for investigating those matters where there are online breaches. Now, before that, we have Section 13, and Section 13 is specifically speaking about an internal grievance officer. So in case the internal grievance officer, you are not satisfied with the internal grievance officer, then you have Section 28, which speaks about the board, and then you have Section 29, which specifically is speaking about an appellate tribunal where the appeal will have to be filed within a period of 60 days. Now, Section 31 also needs to be flagged probably because it also speaks about a resolution through the ADR. Now, in case of data breaches, now one of the provision it speaks about is that if the board is of the opinion that any complaint may be resolved by mediation, then it may direct the parties in order to take this route of ADR through which it can be done through a mediator. And then, of course, you have Section 33, which speaks about at the conclusion of an inquiry, the breach of the provisions, it could also impose the monetary penalty. Now, while we are at it, probably another thing that is related to the breach is not just about the data breach, but those which relates to the data breach, and that relates to how the evidence which relates to the data breach. I mean, if there is a hacked evidence, now can this hacked evidence also, can it be used? Now you have different tribunals, plethora of tribunals, but probably I'm going to be taking the help of three tribunals relating to this. One is going to be the Konoko Phillips. Now this was a case where there was a hacked evidence, and the point here was that now there is a breach, but it does not just stop at a breach. There is a hacked evidence. Will the tribunal also use the hacked evidence? Now, it was not very clear because in this tribunal it was said, we are not going to be looking at that, whether we are going to be using this hacked evidence or not, because the tribunal is not going to be getting into that. Now, after that, there was another very important case which is called as the carrot tube case. Now, carrot tube case almost said, now it does not matter to us, it is going to be evidence, and because it is going to be on WikiLeaks, it is not going to come under a breach, and therefore we are going to still take it. Now, completely converse, diametrically opposite to that, we had another case called the Libanco Holdings case, which was against the Republic of Turkey. Now, it took a completely converse position, and it said, now, because the arbitration, the cornerstone of arbitration is going to be confidentiality and privacy, hacked evidence is not going to be for consideration to us. So one is about the DPDPA itself, it is speaking about the resolution of the data breach. And then in the international commercial arbitration, there has been many tribunals which have spoken not just about the data breach, but also the related issues of what happens, there is a data breach, but then you have a hacked evidence. Now, what do we do with that?
That's really interesting, I suppose. Understood. Harini, so in data processing agreements, how do you categorize liability? And what are the reliefs that one can bring against a company in case there is a breach here?
Yeah. So I think just for a moment, before I get to what we should consider in the context of data processing agreements, I'll just take a moment to explain what data processing agreements are for some of the audience who might be more familiar with the ADR side of things than the data protection. So under various regimes, you have different roles performed by different entities. So normally, an entity that decides the why and how of processing data, that is, they decide the means and the purposes of processing, they are called the data controller. In India, they are called the data fiduciary. Now, in modern commerce, it is very unlikely for one entity to perform all kinds of personal data processing by itself. That's why you have like B2B SaaS companies, you have direct-to-consumer companies, etc. There's a very complex web through which different entities deal with one another in achieving their respective needs. So in this context, you have some companies that essentially perform services for others. They are service providers, but where their primary service is processing personal data on behalf of others, they are called data processors. Now, why is this distinction important? Is that as a thumb rule across many jurisdictions, primary liability or responsibility for compliance with data protection requirements sits on the data controller. What the data processor is supposed to do is, the data processor tells the controller, I am going to process personal data on your behalf as per your instructions. Now, as long as they do that, then they are not liable when any liability situation arises. So this is the very high-level overview of this. There are some jurisdictional differences, and this is relevant exactly to our to Ankit's question on data processing agreements. So normally, you will have a contractual framework by which you are willing to transfer personal data to a processor to process it for you. In that contractual framework, when you come up with it, it's very important to also bear in mind what is the personal data that you're transferring and which legal framework does it fall under. So there are some frameworks like the GDPR where processors also have some obligations on them directly. So you want to make sure your contract captures that. And that in case of any dispute, the liability is going to be, it's very clear on whom liability falls under what circumstances. In certain other regimes like in India, assuming as and when the DPDPA Act comes into force, there's a lot more freedom between the parties in terms of how they will contract. So it becomes even more important for us when we have a data processing agreement to be very clear on what liability falls where. The other element is that depending on which framework applies, it might have an impact on what kind of dispute resolution procedure you can adopt. So again, in India, you could technically say that where there are two corporate entities dealing with each other for data processing and they have a data processing agreement in place, you might be able to have a dispute resolution clause that says that in case of any dispute, we will look to arbitration. In the EU, under the GDPR, for example, you have joint and several liabilities for controllers and processors. Processors are not responsible unless they have failed to comply with the lawful instructions of the controller. But processors can be directly sued by affected parties for compensation in courts. So I feel this is kind of at the crux of our topic, that before you can opt for arbitration as a dispute resolution mechanism, you need to understand the lay of the land very well. So if you're in a data processing agreement situation, you need to understand clearly which legal framework is going to apply to that personal data. And again, thumb rule, which legal framework applies depends on the personal data and the persons to whom it relates, the data subjects or the data principals. Usually it goes with the residents of those data principals. That's at the very basic level. If you want more details, please catch me offline and speak to me or...
Can I ask a small question?
Please, please.
Harini, since Harini said about that. What about the processor of a data of somebody from a country with which India is hostile? We don't have any diplomatic relationships. What do we do? How do we protect this data?
I think that's a very good question, but practically, it's very difficult to have those situations. So if I were to take the most extreme example of, say, North Korea, that's highly unlikely. Unless the person whose personal data you're processing, they have used a VPN. And in all likelihood, they would actually be a state actor in that case, because the ordinary person in North Korea is not going to have access to the internet. But they have used a VPN and they have shared their data with someone in India. So to be very frank, ordinary methods of dispute resolution are going to fail here, but also because it's an absolute edge case where the likelihood of that person being an ordinary actor who will then come and try to exercise data subject rights against you are almost non-existent. Now, what happens if it is, say, someone from Pakistan who's accessing a service in India? At the moment, the DPDPA Act is not in force and there are no restrictions on sending Indian personal data out to Pakistan or Pakistani personal data coming into India. Though full transparency, I don't know what are the data protection laws in Pakistan. However sensitive it may be. And we all know that there are cross-border flows of this kind of data. So again, it comes down to, and because we don't actually have in place solid data protection requirements in India right now, we are still functioning under the SPDI rules. So unless it is sensitive personal data, there's actually no recourse for that other person to come and exercise data subject rights or to raise a dispute. So that's one of the reasons why we have the DPDPA Act waiting to come into force, of course. And also, one of the issues that we have faced, for instance, when more mature jurisdictions send data our way, they insist on things like GDPR has to apply to all data transfers to India, but also where, say, an external entity is setting up a corporate entity in India and their Indian employees' data is being processed by, say, somebody else, they say, no, apply the GDPR. We've seen this in negotiations because their point is, otherwise there is hardly any protection that is left. So we are really in a state of limbo now.
But can that really be done? Is GDPR applicable on a transaction like this in India?
It doesn't apply. But
Okay.
what some others would do, so it depends on which side of the transaction I'm in, honestly. But if I'm on the side of the company that is saying that, let's take an example so it's not too abstract. My employees are going to start working in a co-working space in India. Now, I want to be sure that nobody's going to be picking up all their data or even my confidential data and selling it. So one of the things I might say is, yes, the GDPR does not apply. Here are the list of 20 things that I need you to commit to in my contract. So I will import those kind of requirements by contract into my arrangement with them. When I'm on the other side, I basically say these are GDPR requirements. GDPR does not apply in India. So we are not obligated to comply at this level.
But you can bring it in contractually.
Correct.
And if there's a breach, then you go back to your arbitration clause or you go back to civil
Correct.
courts because it's a contractual breach in that sense.
So
At the moment, we don't have any legal framework because the Act is not notified, GDPR is not applicable.
Yes, but we have something in place, and then of course we have regulatory requirements under, say, RBI, SEBI, or IRDA. Those are fairly robust. But when you're in a more nebulous sector where nothing specific applies, then a lot comes down to contract. But having said that, also many companies in India as well try to aim for various kinds of certification to show that they are able to handle personal data in a certain way. So many of them actually get certified for GDPR compliance. They also adopt things like ISO 27001 and SOC 2 Type 2 certification, various kinds of information security and data protection requirements. One point I want to add here is that there's also Section 43A of the Information Technology Act, under which you can claim compensation for somebody's failure to adequately protect your personal data.
Correct. And that would come in a situation of negligence in that sense. I've given my data. If they show that they had robust procedures in place, but there was still a data breach, somebody hacked into the system despite best measures, then probably come back to the consumer principles of a reasonable service being given.
But having said that, that also flies even under the GDPR, if nothing to at least mitigate your damages.
Yes.
So I've seen cases where somebody claims damages because they're against a company because they've said that you've failed to protect my personal data adequately. I've seen cases where the damages were things like 1,000 euros to say that they took the very best measures they could. There was one small bit of negligence, so this is all that.
Yes, I'm sure every one of us has one password which is in some data leak somewhere, so I guess we have some rights there. Okay. Malavika, what are some measures that can be taken for securing data privacy and data protection in international arbitration? Let's come back to our international arbitration topic. So what measures should we take as, considering our audience is GCs, its practitioners, what measures does one take now to ensure data privacy, ensure protection, not just for their own perspective, for the dispute to maintain the confidentiality, but also to be compliant with global frameworks?
Thank you, Ankit. I think so much turns on, again, what category of liability is likely to result, taking off from Harini's point, right? Foreign seated arbitration, clearly in the EU, very clear we have to comply with the GDPR, but I think there's this big middle range of types of arbitration where, although international, it's not on the face of it, super clear which global framework would apply. So just to paint the picture, we're in an era where international arbitrations are conducted virtually. The arbitral tribunal may sit somewhere and it's foreign seated, so the governing law is of course known, but let's say there are lawyers, law clerks, service providers, transcription services, disparate entities all across the world working in tandem. Or perhaps even arbitrators, disparate entities working in tandem but in different locations, and they come from different cultures and therefore different practices of how to secure data. One thing we very casually do as Indians is we'll go to the Bangalore airport, probably planning for traffic, arrive there 1 hour in time advance, and then log into the public Wi-Fi, right? But as an arbitrator or somebody in an international arbitration, logging into the public Bangalore International Airport Wi-Fi would probably be a very non-secure way to do any business related to your arbitration. So I think this interdependence between all the actors involved in an international arbitration is sort of then making the arbitration vulnerable to the weakest link in the context of a data breach. And we all know, especially LCIA, ICC, let's say, GDPR would clearly apply, and there's a safeguard which then says you don't want to transfer data to countries where you don't have adequate safeguards, right? And that's been in the news of late. So I think that some of the measures that we might think of in the context of international arbitration, maybe it's easier to think of them across categories. What might parties do? What might tribunals do? And what might the institution itself, the arbitral institution itself do? And of late, there's been a really helpful bunch of protocols that's come out from the ICCA in conjunction with the New York Bar and the IBA and the CPR. And they lay out a sort of easy way to think about it in my understanding. And if I had to essentialize just to make it one punchline, I think if an arbitral tribunal were attempting to meet GDPR standards, they would uphold not only privacy but also confidentiality. And perhaps to take off from Harini's point, the easiest way to do that would be to think of the tribunal as a data controller. And then that means the tribunal decides the means and the purpose of exchange of personal data. If you're protecting for personal data, to this degree, you're already protecting a lot of commercially sensitive data that would otherwise need to be kept confidential. Then you take care of the proportionality requirements, you take care of data security, and all of that sort of laid out in the ICC IBA roadmap, as well as the protocol that was made with the New York Bar and the CPR. And I think that one of the learnings to take away from this is that these are protocols that can be adopted by the tribunal. It doesn't have to apply by way of governing law. It doesn't have to apply by way of contract. I think the best practice perhaps might be to decide, let's apply this protocol. And if we were to apply this protocol, then the first set of case management hearings would be to decide on these data security measures. What is each party committing to? What is the tribunal committing to? What are perhaps the data processors, right? Let's think about a transcription service. Might they be a data processor vis-a-vis the arbitral tribunal being the data controller? Then what are the data processors going to be committing to? What do we do if there is a breach? What are the breach response measures we can take? And to the best of my knowledge, there actually hasn't been a GDPR triggering data breach in an international arbitration yet. But I mean, for all we know, the news is yet to break and it's underway. But to my mind, it seems like this is the kind of protocol where it would be easy for the tribunal to say, let's do this as a best practice. Let's have the parties commit to this. Of course, there are foreign-seated arbitrations happening in the LCIA that are bound by LCIA rules which require data protection. I think Rule 30A, Article 30A as they call it, already covers this kind of thing. They address data protection as a matter of privacy quite separately from the confidentiality requirement already incumbent on tribunals. So it's a much easier set of cases to navigate when the seats are LCIA, ICC, so on. Or rather when the arbitration is based on an institution and therefore foreign seated, such as the LCIA and ICC. More complex if it's, I think, other institutions elsewhere in the world and so on. I say all this like I am some arbitrator. Justice Joseph, I was telling him on the phone the other day, should probably tell us his experiences in dealing with international arbitrations because he's the one who's really doing this stuff.
Malavika, see, ultimately the party should agree, no? If the party should agree in the process of the arbitration, or should the parties agree for a protocol prior to commencement of the arbitration? These are very important things. So if we have an institutional protocol which would otherwise protect all those things, that would be the best. So that it will be easy for the, even for the, in an arbitration tribunal, we three of us are from three different countries where we have three different systems and practices and legal regime also. So what do we do even in analyzing the evidence also? It's very difficult. So it's always, I think, better that conferences like this should propose that we should have a uniform protocol, say one or two, maybe like we have schedules now, have stern we have. So likewise, let's have 1, 2, 3 patterns of this protection, whichever one would like to choose. So I think that will be an ideal thing that we should. You can also think of if there is a highly sensitive data, why not you think of recording it in camera instead of putting it in the other system altogether?
Without a confidentiality adjudication on it?
Exactly.
Yes, because then we're going into the security aspect, right? So it's always the human link that's the weak link ultimately. So what Justice Joseph's point is, then you don't put these things into the cloud, so they will not be a breach. So you do it in camera in very different ways. You kind of take away that risk by having this data stored offline in a physical file probably and in camera. So we'll end up going old school to protect ourselves from data breaches and
Just
so
to share experience, since Malvi said, in one international arbitration, we were provided gadgets only of this data, not to be shared elsewhere. It to be seen as such only, and we had to return it thereafter also. So it will not come otherwise in the software, any system software. So we used it and then we returned it.
Correct. That's why you have your nuclear codes on floppy disks even now. So that's how ultimately it's precaution being better than the cure. Yes. Saurabh, finally we'll come to you now. Whenever we discuss technology, data protection, ultimately AI does come in, and certainly in the legal field, AI right now is the talk of the town. There, in my view, I think there are some good positive aspects, probably more positive than negatives to it. Of course, it's going to take some time to develop the way we want it to, but today it's, I think, a fairly useful tool. Maybe not excellent. It's like a calculator perhaps and not an accounting software, that level. But how do you see AI transforming the legal practice? And what opportunities and perhaps what challenges do you see in this?
Thanks, Ankit. And let me begin by saying I'm in stellar company here with academicians, jurists, practitioners whose work on data protection and arbitration sets the gold standard. Obviously, much of the conversation today is centered around privacy, and privacy is the cornerstone of trust. That's what gives arbitration the legitimacy that it holds today. But as you said, and I'd like to suggest that privacy is only one part of the story. We were discussing, sir, that if privacy defines what data can be used, AI is going to determine how it's used, and as we progress to agentic AI, it's going to take autonomous decisions based on that data. In the world of dispute resolution and for dispute lawyers, this is going to be fairly critical. I think two perspectives that I'd like to bring in is that for the lawyering of tomorrow, the role of the lawyer will shift beyond just being a drafter and a pleader. I suspect we will become, as you said, more of strategic overseers. The way the technology stands right now is not super clear. So you are going to be an interpreter of AI output as well. And finally, and most excitingly, all of us will have the ability to cross-examine the algorithm itself. I think that has some value because we will constantly stress test this technology as it arrives in the world of dispute resolution. The second part is, of course, arbitration and litigation will adapt when AI gets in and drives decisions. Cases will be prepared, drafts will be done, likely outcomes will be discussed, but certainly there will be questions around admissibility. I don't think anybody's addressed that today. There are questions of bias, there are questions of fairness. So I think those are issues that we need to address today because AI systems are quite capable of bringing in the same systemic biases that we have as humans. And I think the only way to overcome those biases, for example, is with extensive pre-rollout testing. For example, again, so you were speaking about sort of working in jurisdictions which are not friendly or which have potential security issues. For the kind of company that I work with, or large companies, or most tech companies, I think the use of data, where it sits, and visibility across the value chain is one of our most important considerations when we decide on data. And it is almost a given that we will not host data other than countries that are predictable and safe harbors. So I think that's one way to deal with it. And just again, while this may be oversimplification, but just for the benefit of us here in the room, what's the difference between AI and agentic AI? So AI will assist dispute resolution lawyers, but agentic AI is going to act, and that can be exciting and scary at the same time. Think about your GPS, which gives you the route, and we were discussing Bangalore traffic this morning, to take you to work. Agentic AI, if you click your office, it will take you there, but you can't stop for your filter coffee and dosa because you decided to, right? Because agentic AI has an outcome. So it's so driven by outcome. It's so driven by statistical analysis. I don't think eventually, Ankit, AI is going to be just assistive. I suspect AI is going to morph into an ally. It will come to situations where you will draft pleadings and organize case documents, and tribunals will certainly, I hope so, you concur, that tribunals will start to look at AI for some sort of assistance, of course, maintaining your own independence. That does bring also the question of, I'm sure everyone's asked this question of whether AI is going to make lawyers redundant. Absolutely, absolutely not. I think AI is going to force us to do what the last...
Just not to interrupt, they'll make them more vigilant.
Yeah, I was just going to say that. Unfortunately, we do get indifferent as human beings, but AI is going to force us to redefine ourselves. We will become counsels of AI technology. I will keep saying that over and over again, because AI technology is not the sorts that can be left on its own. And I think as we move forward, we need to remember that courts and tribunals will still deal with elements like persuasion, like credibility, like empathy. So I don't know of an algorithm that will react to a judge's raised eyebrow and reset its inputs there, right? No, there's no AI playbook for court craft. In arbitrations, of course, virtual hearings, and Malavika mentioned, AI-assisted scheduling will be standard. There will be tools that the tribunal will use. But as lawyers, we should be and will remain guardians of fairness. I think we need to ensure that AI outcomes going forward will withstand scrutiny, especially in terms of the due process that the law affords. Finally, Ankit, I think, again, sorry if this sounds like there's a lot of crystal ball gazing. I'm no seer, I'm not a tech evangelist, but I certainly believe in the power of tech to collaborate with human efforts. And I feel like tomorrow's disputes or general lawyers, they will have to be tech-fluent strategists. They should be able to decode algorithms. They should be able to anticipate cross-border regulatory clashes, because you're going to see that as more and more jurisdictions deploy AI. And we'll not only argue the case, but also evaluate the integrity of an AI-driven process as well. So just brief thoughts there, Ankit.
Harini, anything you want to add?
Yeah, I think it's fascinating. I just wanted to say, maybe a few years later, we'll be sitting here at this panel and discussing, agentic AI liabilities and how to address that through dispute resolution. But similarly, I wonder, we already see several countries that are into AI governance. Obviously, the EU took the lead there, but also you see places like South Korea, Japan, and then some others which have more voluntary standards. The US, as always, is a patchwork. Easy to see from far. Thankfully, I'm practicing more in India. But the point is, I think it's really great, the points that you brought out, and that when we look at agentic AI and how it will be used in the practice, there are also scope for disputes out of two different entities that work with each other, and how they deploy their respective agentic AI, and things will always go wrong at some level somewhere, right? So what happens when things go wrong? And how do we address, will we also have agentic AI, dispute resolution mechanisms? And then on top of that, sit the, the human level. So just some musings.
Spoken like a true lawyer, finding disputes in any scenario. But that's fair. That's
They
fair.
say that cynics make very good lawyers.
I
so.
know.
And like to a hammer, everything looks like a nail, so that's what it is also. When we are lawyers, we look for legal issues. But I think perhaps here it's not too far-fetched, because we will definitely see, and there are already disputes going on in Indian courts right now on the use of AI and AI using others' intellectual property and so on. We've already started with those disputes, so I'm sure we'll see a lot more of that coming in the next few years. So Harini, now let's just come back to, let's take a very simple example now. My data, I have personal data, my bank details, maybe some personal details with an Indian company. What recourse do I have as a consumer now if that data is part of a data breach? What recourse do I have? That's one part. And looking at from the lens of the consumer and look at it from the lens of the business now. What should Indian businesses be looking at? Just 2-3 points from you, and I'll take this question down the line also.
So at the moment, in theory, you do have Section 43A, where you can claim compensation. I've seen a few consumer dispute side, a few rare cases where issues of some kind of, failure to protect personal data have come up, but those are also in very, say, strange cases where data was being shared, say, by a bank on a loan application, and then they were sharing it in a certain way they were not supposed to. So some very, esoteric examples, I would say, nothing very standard. Have I seen any large-scale public interest litigation or litigation under 43A to say, you had this massive data breach or a class action lawsuit like you see in the US? No. After the DPDPA Act comes into force, 43A gets repealed. So what you are left with is the right to approach the regulator to say that your data has been breached. But what happens from my current read of the Act and rules is that a penalty may be imposed on the entity that suffered the breach, but that's not necessarily damages to you. So to see how the final rules shape up and how things come out, I think that will be interesting. But this is where we are right now. Obviously, in this zone, what I see more is that the name and shame game is what works more. And, a lot of people are not out looking for compensation per se, but more that they want that security. You cannot, in modern life, work without your personal data being handed over to various entities that you interface with. From the side of the entity that is protecting the data, now in the case of a bank, there are lots of requirements under RBI-related guidelines, frameworks, directions, etc. But if you look at other kind of entities, again, the most significant thing is to show that they are trustworthy by adopting good data protection and data security practices. I don't see that as a negotiable. That's something they will have to do.
Why is this act yet notified? Despite we started with the Puttaswamy in 2017. The genesis is that decision 2017. 8 years down the line, we had a committee set up. Committee gave its recommendations. The bill was introduced in 2022, if I am not mistaken. But we made an act, and we are still not notifying the act. That's very, very strange. I think conference should adopt a resolution asking the government of India to notify this. I'm sure no governor or president is actually withholding it, because the assent issue is not, this is central act.
I believe now, I think I read somewhere that probably next session it's going to get notified by the next session. Possibly, I don't know. So maybe by the end of this year we might...
No, notifying, you don't require a session. Notifying is an executive act because it's done already.
But I think there was some news about them waiting for this session. Another reason
session to be over,
yes.
yeah. So that's avoid some unpleasant discussions maybe in the session.
Yes.
Could be. One thing which Mr. Saurabh said, probably we need to think as lawyers and the members of the tribunal also, the possibility of bias in AI. That could potentially mislead the arbitration lawyers and the tribunal members if you over-depend on that.
Definitely.
That caution, that's why I said, no, it has not become redundant. We have to become more diligent and vigilant on processing or taking recourse to that data as well. Assistance, yes.
Saurabh, from your side now, tell me as an in-house counsel, what are your concerns with data protection? How are you dealing with these issues? Have you implemented systems already? How eagerly have you been waiting for all these years for the DPDP to come? Are you sick of waiting for it to come? What is your in-house perspective?
Yeah, absolutely. I think we were ready for data protection 3 years back. I think there's going to be a time when we'll have to re-ready ourselves. But look, as you think about moving from digitization to delegation, coming back to AI again, I think there are some fairly serious concerns that we're currently grappling with. For AI to be more effective and evolving into agentic AI, you're now going to need more extensive access to data, enterprise data. And there is an absolute possibility that AI technology could, unless we build sufficient guardrails, have the ability to blur the lines on data use, on data retention, and potential infringement. So the mantra would be guardrails right from the beginning. It's extremely critical for enterprises and individuals to encrypt data, to have authentication protocols in place. 3 ways to look at this. For companies, we have a slightly more convenient arrangement, which is we already are sensitive to data, strong contracts, very strong clauses, indemnities, penalties, financial consequences. Public-facing deployments. I am aware of a project where the Abu Dhabi government is working on AI initiatives for citizen governance. A number of state governments have been speaking to us saying, how do we deliver citizen benefits using AI given the sheer scale we have? Extremely critical that when AI enters public and citizen data impacting people like you and me, there needs to be strong resiliency mechanisms and extremely strong focus on complying with GDPR, if not DPDPA. I think we are using that as some sort of gold standard right now until we get to the DPDPA. Finally, I think for arbitral institutions, and again, Malavika, you spoke about that, the additional responsibility of being data controllers will go beyond just the rules of arbitral institutions. You will need to be more intuitive about how you're using data. You know, the instance you gave about the airport is a fantastic one. We have that.
If not innovative, because keeps changing, so you need to innovate,
all the
each
time,
time
sir.
we need to, then comes with other methods.
All the time. And frankly, I think it's quite disconcerting because when you receive data or you receive pleadings, you receive documents, is this the real data? That wasn't a question that somebody asked earlier because you were on an affidavit, you'd go to jail. Today, who are you going to put in jail, sir? You won't find that. So look, again, one principle that we repeatedly recommend, and some of us as tech evangelists say, is trust but verify. That is absolutely critical. There's got to be the ability for us to have separate rules for separate subsets of data, primarily on the business side and on the individual side. So that's one thing that we focus a lot on. If there is sensitive personal data, then there's a whole new security and authentication protocol around that. I hope all of us have stopped giving our phone numbers in retail shops. It used to be okay to do it 5 years back, but fortunately now all of us have that sense. So I guess essentially the same principles, but we now have this new truant child in the midst of us, and we don't know what tricks it's going to play. As Sir said, and as all of us as dispute lawyers would agree, we have to be cynical, skeptical, and continue to exercise massive diligence.
All trusts are verifiable now.
Yes. So Dr. Sapna, we will be ending this session in about 8 minutes so that we can open up Q&A. So some concluding remarks from you, and then I'll just go to the rest of the panelists.
Yeah.
Yes.
Yeah, so there are 2 things that I would like to flag in addition to what we have already spoken about in the data protection. One is with respect to the discovery exercise, and the second one relates to the expert witness. So with respect to the discovery exercise, now where the data review process is given to a third party, then that third party gets into the shoes of a data processor. So that again is, that is a potential danger where the data protection could be be, compromised. Now, the second one relates to the expert witness in the international commercial arbitration. Now, when we have an expert and we give all the personal data, the sensitive data, for the expert to give his expert opinion on, that also could be another feasible or another potential danger for the data protection compromise. So these were the two things that I would want to flag. But apart from that, as concluding remarks, it is not just about law or the regulations. It is about the technology itself. And at the end of the day, it is about, like what the other panelists were saying, it is about the trust and, the human failing at the end of the day. So the DPDPA, when it comes, they have a whole lot of things about, in case there's a data compromise, what are the provisions that will have to be put in place for the data compromise. But then we are yet to see how this thing is going to take on. There's a regulator that you'll need to go to, and then there's a board, and then there's an appellate authority. We also have the mechanism of the mediation that can be used in the provision itself. But I think at the end of the day, it is just for us to wait and watch how this is going to unfold itself.
Thank you. Dr. Malavika, can we have your concluding remarks, please?
Thank you. Still awkward when I'm called doctor, because I feel doctors are people who can make health a priority, not disputes. So I just wanted to say some things about party autonomy, taking off from Justice Joseph's point, because this is in trying to uphold data protection through, let's say, a global framework, we might have to derogate from what parties have agreed to in contracts. So maybe the tribunal is then pushing parties to do something like come to an agreement in a case management hearing, quite beyond what was conceived of as the party autonomy that led to the reference of the to the tribunal. So one of the things that the protocol that I'm mentioning, the ICCA, NYC bar, CPR protocol lays down is that parties A, must endeavor to agree on information security measures, and B, they must endeavor to agree to not a one-size-fits-all information security measure, but reasonable measures for their own dispute. Reasonable measures based on their stakes, guided by the proportionality principle that undergirds the GDPR. So I was just, as Justice Joseph said that, and we were all talking about, what happens when agentic AI then leads to liability questions. I wonder, and Saurabh mentioned, it's not going to be, it may be long before arbitral institutions start encoding these principles. So in that interim, when arbitral tribunals are sitting in international arbitrations and having to do these high-risk data transfers, and the institution doesn't have a rule, what are the ways in which a reasonable set of data security measures can be created by the tribunal as a sort of agreement for that particular dispute? Would that sort of fit within the framework of party autonomy? I think these are questions that we might still have to think about a little harder in arbitration, in the arbitration academia, arbitration bar, and perhaps even the intersection, which is this conversation particularly.
Thank you. Justice Joseph?
Thank you. I have spoken more than what I am expected to. But still, I would like to say share one experience of experts. We were really shocked in an arbitration tribunal. Two experts on the same subject giving absolutely contradictory analysis. So, in a tea session, we just asked them, they said, no, they used different AI tools. Different AI tools. So, never depend on, after all, it's a machine. It cannot go to the level of your analysis. It can analyze only what is fed. That's number one. I would also like to ask Ms. Jayesh from Singapore, as far as this data protection is concerned, the jurisdictions elsewhere, probably you'll be, as an anchor, will be asking, I think they have firmer practices there, I believe.
Harini?
I'm saying jurisdictions outside, how do they actually do their budget? Just a concluding remarks.
Yes, yes. I'm not going to go off into a whole new lecture, but I think in the context of arbitration, I think Malavika's covered it quite well. That certain centers and certain jurisdictions employ specific protocols Aside to that, there are many countries which by now have very standard data protection laws. I know the GDPR is commonly referenced, but even aside to the GDPR, you have many other jurisdictions which have had strong data protection laws for many years by now. So some jurisdictions like Japan, Korea, even Israel, even Singapore, China as well, absolutely. So where there are already existing strong data protection laws, I would say you would defer to that and understand what is the role of each participant in an arbitration under that regime. So go back to those questions around who's a controller, who's a processor, what personal data is being processed, are there any international transfers, and if there are, where, and is this permitted? If not, do you need a specific mechanism for the transfer, and so on. So bring it under the applicable regime. To understand which regime applies, generally look at the personal data itself. I will stop here now.
And we are bang on schedule. So it's 11:30 and we'll just open it up for audience questions. I'm sure there are a lot of questions on most of the topics that were touched. So if there are any questions, please raise your hand and the organizers will bring a mic to you.
I asked just because being an old institution there, have you come across any such situation where you had a problem with this data protection?
We can't see from here.
Oh, okay. That's the problem in analysis also. It can be blocked to some extent. So. Or some of you could share some experience if you have any from other jurisdictions.
I believe somebody.
Friends are there. Yes.
Hi everybody. I am Murali Krishna from Mandapati Legal Services. I come from Hyderabad. Sir, it's a privilege for me to attend this event. Sir, I would just deviate a little to what we have discussed. Sir, in India, the biggest concern when somebody as a litigant comes to a practicing advocate or comes before a court is the consumption of time. I have a blend of traditional practice along with the corporate practice. Most of my clients say the same thing. Sir, how much time would it take to close this litigation? Now here with the panel, the eminent panel that has discussed, I understand is the breach of the data is again creating one another round of litigation. And as the gravity of this litigation increases, it's directly proportional to the kind of international arbitration, national arbitration. It is directly proportional to the litigation. The gravity is directly proportional. So isn't there any mechanism? Somebody says that this litigation can be closed within so-and-so timeline. Because whenever I answer my clients, I tell them, somebody is saying that it will get closed in a span of a specified time limit. Courts are so dynamic in nature. Sir, I need not say anything about the courts.
I can say, only solution is the parties agree, let us close it. Number one. Number two, let us trust this tribunal and have a settlement. Under Section 30, we have an internal arbitration. Section 30, let's have an award on settlement. If that is there is a closure. Otherwise, there is always a potential. We call it 34. Even if we limit it to public policy also, we will find, we are all lawyers, we have our own ingenuity, to find grounds to go into. Today we have this data, so we will find some data breach coming in. So it has gone into the, the public policy. So it's very easy for us. That's why we are lawyers. That's in our blood. But only way to, if you want closure, use the right word closure. Closure, the only possibility is to have either that Section 28 to give an equitable jurisdiction to the tribunal, becomes the end of it. 2, under Section 30, go for a settlement on mediated or settled terms. That will close everything.
Thank you, sir.
But so that raises a very interesting topic. Now I think if a party wants to drag out proceedings more, allegations of breach of data privacy can become a parallel challenge and can take it into a different tangent altogether. You can probably stifle all enforcements on this
The
basis.
compensation that somebody could claim or that breach is again arbitrary, sir. Like I might claim a compensation stating that my brand is worth so and so.
Another arbitration clause for that.
Yeah.
Which means that a round of litigation again keeps on increasing.
coming back to Sir's original point, right? So he said this is not, we have to resolve the disputes. It has to end somewhere. It's not just having a system for dealing with the disputes. You have to actually look at the resolution. Where I suppose we'll go back to mediation, which is honestly the best way to close something is when both parties are satisfied. If both are not satisfied or equally dissatisfied, it'll never end. So unfortunately, I guess we are stuck with that system of things dragging on, but perhaps more court infrastructure, more institutions, more arbitration institutions, more trained
Putting an
arbitrators.
absolute quietus to such kind of issues probably isn't proposed anywhere, is what I understand, sir. If something is there, do let us know.
No, it's fearful actually. Litigators, I see litigators probably using this as another way to drag on enforcement proceedings. I believe someone in the last row has a question.
Thank you. My name is Pavan Srinivas, and I'm an advocate who's practiced in England and Wales as a solicitor and in Dubai as well. And so to answer your question earlier, and taking on that question also, there is a bit of a danger in the solution being proposed, which is in an arbitration when someone's personal information is disclosed and it puts that person in danger, in physical danger because of that disclosure. So for instance, I was in an investment treaty arbitration against a Middle Eastern state where the investor was also conducting business in that state. But there was a lot of confidentiality about who the promoters of the investor were, who the parties involved in that investment treaty arbitration were. Because if that information got leaked out, there was risk of retaliation. Now, there is no way that you can mediate these kind of things. Rather, even if you mediate, what protection are you going to give these people when they are very much in the country itself, against whom they're suing that country? Now, I understand this is very limited to investment treaty arbitration, but how would you address this kind of a...
Depends on the stage where you mediate. If you see a potential for the data disclosure and then mediation, please avoid that. Then have a mediation at the very initial stage. Because mediation is for not finding an answer to a question. Mediation is finding a solution to a problem. Therefore, do it at the very initial stage so that there are no sensitive disclosures. That's one way of doing. That's the prudence that we use. No? In commercial parlance, 50% is your prudence. In advocacy, it is skill. But in commerce, you need prudence. You have to see beyond what even the lawyers could see.
Is there any other question, anyone? Okay. Yes.
What about publication of awards? That's one thing Malavika just asking. This high risk.
So I've always been concerned with that because when there's a challenge and then the 34 petition goes, your entire award is part of the 34 petition and that's public. So at least your awards you can still keep secure to some extent. But the facts are so extensively produced in high court judgments and then even if it goes up to Supreme Court, and those same facts are quoted in other judgments also. So I find it very concerning for my party sometimes. It may not be entirely sensitive information, but nonetheless, it just shows that we don't have so much regard for that contractual privacy and for that contractual confidentiality. I'm sure Saurabh has faced these
Need
issues.
not be sensitive. As you rightly put, it could be some interested situation also, no? Because I can make use of this for my investment elsewhere or in my ongoing investments also.
We use it very often. So if there's any party opposite us, we see every litigation that party has ever, any reported judgment at all. Reported, unreported, we pull out pleadings because we can. You can get certified copies and invariably use it against them also.
Yeah, that is something which we need to definitely deliberate.
One thought I had on this, I wonder why we don't file more IAs along with our 34s or 37s, just seeking permission from the court to redact.
Yeah.
It can't be that impossible to argue in the first hearing, especially given the provision exists in the Arbitration Act for confidentiality. And with the DPDPA coming in, I'm sure people will have good ground to file IAs with their writ saying, redact my personal information. It should not be available to the public or, God forbid, Indian Qanun, right? My pan on Indian Qanun. Do we want that? So I wonder why we don't do that more often in just classical court
And
remedies.
what worries me more, in most jurisdictions, if you're filing an affidavit with your pleadings, they will ask you to file your Aadhaar and your PAN card with that. So
Very
at,
dangerous,
at
very
the very
dangerous.
least, the affidavit has your name, your age, your address, and that's public.
And Ankit, in proceedings that we've been involved in where there's been data that's asked that has absolutely no relevance to the question at hand, it's basically leverage used by the other side. And essentially, our ability to come in and plead confidentialities itself puts us in the dock sometimes, because the obvious question that people start asking is, what do you have to hide? So that sensitivity, sir, to the fact that there is certain data that is sensitive and that must not be disclosed, and if it's not germane to the matter, I think that has to pervade across all levels of the ecosystem. I don't think it's gotten there yet, sir. So I think it will evolve.
Rather than hiding, is protecting. Because if somebody asks you my identity, I always give a masked Aadhaar. It's because he doesn't have any, the one who needs only identity. So you always mask. It's very, very dangerous to give this Aadhaar card, I tell you, and your PAN card, both. But always give the masked ones.
I was just going to add that, in a sense, you also see the same issue across any governmental or public record maintaining organization, right? The classic example, you would have seen it everywhere, and I've personally experienced it, is when you give details to MCA. So the DPDPA Act, for instance, does include an exception for when records need to be made public, where someone needs to collect information, personal data, to make it public under certain circumstances. But I wonder about a purpose limitation. Now, because I give my data to MCA, I understand that it can be used for, say, diligence purposes or verification purposes. I am not giving it to get 100 emails and 100 calls from people to say, do you want to open this kind of account, or do you want to open that kind of account, or you're registered as a director in this company, do you need that service, do you need a website? And so that purpose limitation, I'm waiting to see if that's going to catch on, because otherwise, public records cannot be a free for all for marketing.
Just last one word on this. Since all of us are sharing this, since the scope in 34 is very, very limited, why should the 34 forum require the records? Why not only the award? Why don't we think about it? Because we are either attacking it on the guise of fraud or on public policy. Public policy is not based on facts. Based on public policy is what we analyze it. So not analyze, approach it. Whether something is against public policy of India or not. So fraud on public policy. So why do if it is an appellate court, yes, all records are necessary. But it's not an appellate court, 34, and even 37 thereafter also, is not an appeal. So why don't we suggest that, in 34, no court shall be required, court shall require the parties to provide the records, produce the records. Let only the award be there.
That's interesting, sir. But as a litigator, I worry about that, because someday I may need that record there, someday I may not. But yes, that's a decision for Parliament. Yes.
Yeah, you keep it, but why should it go to the court? Because it goes to the court, it's writ large, then access becomes very large access.
No, but we touched upon affidavits and personal data being in pleadings. Now I have a very personal question here. I am served with pleadings from the other side, which has personal information of the plaintiff. Let's say I'm for the defendant. Am I a data processor? Am I a fiduciary? Who am I under the DPDP? Do I need to be looking at this? Because I'm served with an affidavit. Do I need to ensure that that data stays secure in my systems? Or is it because they've given it to me voluntarily, I have less liability? I don't know. What happens, Harini? Please tell me I need to implement.
I think you need to keep it for you, because the proceedings, if they are confidential, it becomes a binding confidential clause on you also, though it is not said in so many words, because you are bound by the principle of this confidentiality, and therefore what is served on you is for your consumption, not to be not for any transmission.
In one line, if somebody gives it to you with consent or otherwise, that is the basis on which you are collecting the data and the basis on which you are processing it. It doesn't remove all the other obligations. So all the other obligations remain.
So will the DPDP require me to implement some solutions for this? I understand I'll keep it confidential. I don't release those pleadings to anybody at all. That's anyway our responsibility. Is there any additional compliance that we need to do now? Because see, companies will also be served. Like Saurabh, for example, somebody is suing your company or you're suing somebody else. those details are there with them.
For sure. So, Ankit, I suspect what's going to happen is that we are going to see the rise of consent managers. So nothing that we will do now is going to be governed by us, because you've only given one example. I'm sure you have a million briefs to handle. So essentially, you're going to talk to a consent manager, and that consent manager is going to ensure that on the data subject side, the disclosure is clear and purpose-built. The latest DPDPA rules are now saying that if you give consent, it has to be specific consent. So I think there is a awareness around that. And the second is that it is not for disputes lawyers to be able to solve this. We are going to have tried and trusted systems, because that is essentially what is going to be able to help you focus on the dispute, right? Otherwise, the start of your obligations, really what Justice Joseph said. You start with confidentiality, start with attorney-client privilege. So absolutely.
I have one point
Yes.
which plagues me. What happens with the retention? I mean, once the data is given, I mean, is it that you have given a perpetual consent to it? Now, what happens to the retention part of it? So is it that post-service, the data will have to be deleted, it will have to be written? Do we have anything in the GDPR on this?
So very briefly, consent is always tied to the purpose for processing. So if you are giving your data for processing for a specific purpose, then once that purpose is achieved, that data should no longer be retained, personal data. That's it.
It should be either returned or destroyed.
And sir, I think most organizations, including institutions, will inevitably now give commitment saying after the hearing is complete, we will only retain the records for 180 days thereafter.
3 months.
Or
3
some
months.
such
We,
thing. Yeah.
we strictly in all awards, I send a communication. I'll retain it only for 3 months, beyond which if you don't take, we'll destroy it. And we do it. Because it is a very, the data, the type of data they provide are very potentially very dangerous for to be exposed to others.
All right, so we are getting indications that time is up. So thank you to all the panelists. Thank you, Justice Joseph. Thank you, other panelists. It's been an intriguing session for sure. And as usual, when we talk about AI and data privacy, we end up leaving with more questions than answers. And I think till the DPDP comes into play and things like that, these questions are only going to increase. We'll have answers, but those answers will beg probably another 10 questions. That will keep lawyers busy, that will keep in-house lawyers busy as well in compliance. But we wish everyone the best and wish everyone has their privacy safe. Thank you so much.
And thank you, the moderator, being quite moderate.